We are recording this meeting. Brynelson,
Present.
Fleischman,
Here, at least physically. Mentally, not so sure.
okay.
Uh-oh.
Oh. Hamilton,
Present.
Hartston,
Here.
Shining,
Here.
Judge you.
Here, thank you.
Thank you. I think our brains are all a bit fogged from all the smoke.
Yes.
Okay, so we have two speakers tonight. And what I'd like to do is start out with those two speakers. We've asked them to really focus on the specific remaining issues: wage garnishment, car repossession, utility shutoff, with an even more specific focus on walking you all through the process for each of those types of matters. So as opposed to maybe giving their opinion about whether or not paraprofessionals should do the work, just to make sure you all have a good understanding of what the work is, because I think we've kind of struggled with these three remaining areas. And then we'll take public comment just a second. And then we've got some of the requested data to share with you that you asked for. Steve.
I was just going to ask if we're doing public comment first or second.
I want to just continue with the pattern, if it's okay with you all, of having our invited speakers speak first, just to be respectful of their time, and then moving to public comment. Okay, all right. So we have Elizabeth Gonzalez with the Public Law Center, and Abbas Kazarounian. And Elizabeth, why don't you go first?
Sure. Hi, everybody. I'm with Public Law Center. I guess you can't really see the background, but there we are. I'm the directing attorney of PLC's Consumer Law Unit. And so I'm just going to start talking. If you guys have questions, I'm happy to be interrupted. I'm starting to teach a class on Monday, so please interrupt me so that I can practice for that class. But let's start first with wage garnishment. So because I'm not sure who everyone is, and I'm sorry for that, do you want me to go into how a debtor is in a situation where they have a wage garnishment, or do you guys already know that process? Like the judgment's already been entered, a rate's already been taken?
Speaking for myself, I think we know that. I always wondered why we didn't just do quick introductions for our guests. Sometimes I wonder for them if they know who we are.
Yeah, let's do it.
Okay, I'm Erica Yu, and I sit on the court in Santa Clara County.
I'm Steve Fleischman. I'm an appellate attorney at Horvitz and Levy in LA.
Stephen
Hamilton. I'm a family law practitioner in San Luis Obispo County, and I'm the representative from the California Lawyers Association.
Amos.
My name is Hartston. I'm a deputy attorney general, and I work in the consumer law section.
Julia.
I'm Julia Brynelson. I've been an attorney for 30 years. I primarily teach now in community college in Sacramento in the paralegal program that is approved by the American Bar Association.
Carolyn.
Hi, I'm Carolyn Shining. I'm a solo attorney in Los Angeles. I'm also a registered patent attorney. I represent small businesses and plaintiffs in class action, consumer law, and those kinds of things.
Right, and then you've got three staffers here.
I'm Linda Katz. I'm the lead staff from the State Bar on this paraprofessional working group.
And I'm Leah Wilson, a consultant supporting the effort.
And I'm Araya Rahimi, and I'm also supporting this group.
So I'm just gonna start with what happens when a defendant or judgment debtor gets notice of the wage garnishment and sort of the next steps. So again, if you guys have questions, interrupt me. If you already know what I'm saying, just bear with me. So the first thing is that we want to understand that there are two ways that a debtor gets notice of the wage garnishment. It should be served on them, so they should get it by the sheriff. Unfortunately, I would say about 90% of the time, the creditor has an incorrect address. And so the way that the debtor or judgment debtor finds out about the wage garnishment is directly from the employer. So they usually are just told, hey, we're gonna have to garnish your wages. And the person is like, what? And depending on the employer, depending on how big the employer is, depending on what background the employer has, they might say, you need to talk to a lawyer, or they might give the judgment debtor a copy of the notice to the employer, which has some information. They may say you need to talk to the sheriff. So it depends. So the first step is educating the judgment debtor on what he or she has to do. And that's something that in a perfect world, they would have been served, they would have gotten the information, they could have called self-help and been referred to public law center or, a lawyer referral service. But so in addition to the two different ways people have to get notice of the wage garnishment, there's probably another 8 to 10 ways that the judgment debtor is made aware of what they have to do. And some of those ways are correct and some of those ways are not. So let's go with the incorrect way. So there are times where an employer says, we're going to have to garnish your wages. You have to file a claim of exemption. Here are the forms. And then the employee says, okay, and fills out the forms and doesn't realize that they have to send it to the sheriff, but let's assume they figure that out. So the employer says, you need to file a claim of exemption. You need to fill this out. The employee does it, figures out that they have to go to the sheriff and give the sheriff the original and 2 copies so that the sheriff can serve 1 copy on the creditor. And then they have to wait to determine if the creditor is going to oppose the claim of exemption. If they don't oppose the claim of exemption, then the garnishment won't happen or will stop. And any money that the sheriff has already garnished will be returned to the judgment debtor. If the creditor opposes, then the defendant will get notice of a hearing on his or her claim of exemption, which these days is, at least in Orange County, they're being scheduled out about 3 months. So if the employee, and I'll get to the timeline in a second. So I'm going forward and then backward because time has no meaning these days. So the hearing is set, and then we'll put a pin in that and then come back to what happens at the hearing. If the employee, and so going back to the timeline, from the time that the notice of wage garnishment is served, and usually it's served by mail, so they have 15 days. So it's 10 days from service. So if it's personally served, the employee has to do this within 10 days. If it's mailed, they get 15 days to send it to the sheriff. Doing it within that time frame doesn't stop the wage garnishment. A lot of times people think that stops the wage garnishment. It doesn't. All it does is tell the sheriff to hold any money that is garnished until the claim of exemption is decided. So if the creditor doesn't oppose, any money the sheriff holds goes back to the judgment debtor. If the creditor opposes, the garnishment continues until the hearing on the claim of exemption is held. And if the court finds the money should be returned, then the sheriff returns that money, minus the $12 per paycheck garnishment fee. So this is also confusion for some of the judgment debtors. They get a garnishment, and then they also have a line item for a $12 sheriff's fee. So every garnishment comes with an additional $12. The judgment debtor doesn't get the $12 back. So if the judgment debtor does not submit the wage garnishment, the claim of exemption within the 10 or 15 days, the garnishment continues like it would have in the other situation. But in this case, the sheriff is now directly giving money to the creditor. There's no hold time. Once the claim of exemption is filed, well, I guess given, it's not filed with the sheriff, given to the sheriff, at that point, the sheriff starts to hold money. So if the garnishment has been going on for 5 months, 5 months of money has gone away. Once the claim of exemption is filed or given to, let's just say filed, and we know that that means given to the sheriff. Once a claim of exemption has been filed, then the sheriff starts holding funds, and then we go back to the same thing. Once the hearing on the claim of exemption happens and a determination is made, the sheriff gives back any money that it was holding from the time the claim of exemption was filed. So that's sort of the general, if everything sort of goes as planned. The issue with this is that there is a California, it's not an issue, but one of the challenges is if the employer is the one giving the judgment debtor the information, which is often the case, the employer doesn't usually give a very important piece of information, which is if you are taking home less than 40 times the minimum wage, your wages are automatically protected and the employer cannot garnish. So what that means is anyone who is earning minimum wage, working 40 hours a week, their take-home pay is going to be less than the minimum. And this is determined by take-home pay. So that means they do not have to file a claim of exemption in order to protect their wages. What happens is, even though the instructions for the employer explain the formula, the employer doesn't actually, usually it's a company, so it's the payroll company that does that. So the employer itself, their HR department doesn't necessarily, if they even have one, doesn't necessarily do that math to say, oh, but don't worry, you don't have to do a claim of exemption because your wages are automatically protected. So the challenge for the judgment debtor is if they don't realize their wages are automatically protected and they file a claim of exemption, their wages, there's still going to be a hearing on the claim of exemption that was filed unnecessarily. And depending on the judge making the decision, the judge, at least in Orange County and in other 8 areas, the judge will literally say, how much can you afford? So the judge will say $50 a month, once a month, that way you don't have to pay the $12 every time. But what that means is now the judge is ordering $50 a month when had the person not filed the claim of exemption, they wouldn't have had anything. Yes, Ms. Yu.
Thank you so much, Ms. Gonzalez. That's okay. So when you said 40 times minimum wage, so they're working 40 hours a week. So it's 40 hours a week times minimum wage. So per week.
So depending on how they're paid. So if they're paid per week, and it also depends on, the statute says it's wherever you're working. So there are some counties that have a higher minimum wage than the state. So you go with wherever the person is working. Okay. So it's basically right now in Orange County, it's either 480 take home or 520 take home.
And it's per week, not the per pay period.
Correct.
Okay.
So if they're paid on a monthly basis, you multiply the weekly by 52, divide by 12 to get the monthly.
Got it.
If they're paid every 2 weeks, you multiply by 26, divide by 12 to get the monthly. So there's different formulas. And all of this is laid out somewhat clearly in the notice to the employer.
But now you're saying monthly, and earlier you said per week.
So it's per pay period. So sorry, let me back up.
Okay.
The baseline is per week.
Okay.
But if their paycheck is not per week, then to determine whether they're protected, you have to look at the paycheck, the take-home amount, figure out how much they're paid before taxes, just to get their minimum or to get their hourly rate. And then if their every 2 week paycheck is over X, if their monthly paycheck is over X, then there can be a garnishment.
Okay, thank you.
Sure. So we're at the stage now where someone who didn't need to file a claim of exemption did so because they thought they had to. And now the judge has said, I don't want to hear it. I just want you to tell me how much you can afford once a month or once per paycheck. So now the employer has a court order saying you must garnish $50 a month. So even if the employer has figured out, oh, this person earns less than a minimum, I cannot garnish. Now they have a court order telling them they have to garnish. So now the employer is abiding by a court order. So any questions on those scenarios? Yes, Ms. Shinning?
Hi, sure. You mentioned that the judge has to sign that order. You're saying that the courts don't double check to make sure that's okay?
Yes. I think all the courts are different, but at least in Southern California, it is not uncommon for people to be ordered garnished when they shouldn't.
And do you have to turn people away because of the time limits?
Oh, because wage garnishment, the time limit is only for the sheriff to start holding funds. So if someone has been garnished for 5 months, you can still do a claim of exemption. They're just not going to be able to get any of that money back from the sheriff until the claim of exemption is in the sheriff's hands.
And one more question, and then others probably have. Is there, and maybe Mr. Kazarunian can answer this too better than I, is there a private right of action against an employer for messing this up?
So that's a really good question. And from our research, you would argue the labor code, I think it's 204. I used to do employment and labor law, it's been a while, but you would argue that the employer is wrongfully deducting from your paycheck, but the defense is going to be what I thought that we had to. So that's sort of a wage and hour issue. So it could be a private right of action if you're bringing it under the labor code or going through the labor commissioner. But if the other speaker has additional thoughts, I'm happy to hear them.
I think, I'm sorry, carry on, Your Honor.
Oh, I'm so sorry. Thanks. Are child support garnishments the same or different?
They're different.
Yeah, I figured. Okay, thank you.
Why don't we let go ahead. I think, and I'm sorry, to Mr. Kazarunian, go ahead and speak.
Sure. I mean, just to compound on what Ms. Gonzalez said, I think, yes, there's a potential labor code violation. And then as far as, ancillary consumer statutes that could be used, there's conflicting law in the FDCPA, for example, whether the employer is on the hook, but certainly the creditor or the debt collector would have potential liability for collecting a debt that's not valid under the FDCPA and the RFDCPA, depending on whether they're the original creditor or a third-party debt collector. But when it's my turn to speak, I will certainly be talking about the overlap on how I exercise and I practice this area of law. I think, but what Ms. Gonzalez is saying procedurally and the mechanism that is used in the court system on wage garnishment is thus far pretty accurate.
Julia.
Yes, I had a question for Elizabeth. So when your clients come to the Public Law Center, do they, what are the restrictions in your intake? Do they have to be at a certain income level, or what is the profile of the person that is eligible for your services?
So generally speaking, PLC does have income and geographic limitations. PLC is not LSC funded, so we have a much higher income limit than like a legal aid. So you're testing me, I don't know off the top of my head, but I think for a family of one, their gross pay can be no more than $3,800 a month. So it's, whereas legal aid, it's I think like $1,700. So we have a larger ability to assist in terms of income. Our clients, we do serve Orange County, and I'll be honest with you, we have made exceptions for both depending on the situation. So we have like a veterans unit as well. And so a lot of veterans get served in Long Beach. And so if someone is in Long Beach and is a veteran, we will probably help them with the claim of exemption just because the geographic is close enough and it fits into our veteran project. If someone is over 60, we have an elder justice project. So if someone's over 60, we don't look at income at all. So if you're over 60 and you come to us, you qualify for our services.
Thank you.
And I just want to clarify that the over 60 piece, that is written into the IOLTA statute.
Yes.
So, all IOLTA funded programs are able to do that. But I also wanted to say that the minimum wage, at least in some counties, certainly California, that would make you ineligible at the 125% of poverty level, federal poverty level, for a lot of IOLTA funded services, where we have many $20 an hour minimum wage jurisdictions here.
Yeah,
so,
and I feel like that's a lot Northern County, right? Like,
yeah, San Francisco, Berkeley, around here we have that.
Yeah, I think our highest is LA, which is 15, I think. But remember, sorry, we're not talking, in terms of the claim, the wage garnishment, we want to make clear that it's take-home pay. It's not gross. So after taxes are deducted, after FICA and the government takes all your money, just joking, that's the number in terms of whether or not you can be garnished.
Okay, so even higher, basically.
Yeah, yeah.
Does anybody else have questions about wage garnishment? Okay, Amos.
Ms. Gonzalez, just two quick questions, and thank you for being here. This is very helpful. I'm wondering what the standard is for getting an exemption, assuming you are not, you're above the minimum automatically exempt. So if you file a claim of exemption, what's your standard of proof and what do you need to prove? And are there any other common responses to a wage garnishment other than filing a claim of exemption?
So first question, so assuming you are over the minimum requirement, so you can be garnished, and so let's actually talk about that as well. So once you're over that threshold, there's two ways to determine how much is garnished. So when you're over the threshold, it's either 25% of your take-home pay or 50% of the amount above the protected threshold, whichever is less. So if someone is bringing home $620 and they were in the $15 an hour minimum wage, so their automatic protection was $520 and they're bringing home $620, the employer can garnish half of that, which is $50. So that's the other thing to remember is it's not like all of their wages are garnished and it's not like 25% of their take-home wages are being garnished. That 25% take-home of garnishment usually only applies when you are a higher earner, okay? So if you're not in that category, the claim of exemption requires you to submit two things. It's a claim of exemption that explains why, and then a financial statement that supports the why. So the main, for lack of a better term, defense to have wages garnished is that my necessary expenses exceed my income, or they're close enough that I shouldn't have to be garnished. And so the financial statement is a 2-page form, and it can get a little confusing because while the threshold is based on the $520 per week, or there's a formula for that, the claim of exemption financial statement is by month. So what's your monthly gross? What are your monthly payroll taxes? What's your monthly take-home pay? So when the judgment debtor is trying to fill that out, they have to, if they get paid by week, they have to know how to take their weekly payroll deductions and get it into a monthly. If it's bi-weekly or every other, or the 15th and the 30th, if there's a different form.
And are those judicial counsel forms?
They are. So you have your income. You have to, if you have a spouse, the spouse also has to sign, you include all of the household income. So, and then you also have to include all of your household members. So spouse, children, and what their pay is. There's a small section on assets you have to fill out. And then it's really the second page of the financial statement where when judges review it, that's what they're looking for. And it has a list of all of your monthly expenses. And they're sort of categorized broadly. So judgment debtors sometimes forget their expenses. So like it'll say, the easy ones, mortgage, homeowners insurance, utilities, groceries and household expenses.
And Ms. Gonzalez, do you mind, if this debt is less than $25,000, would that be filed in the general civil limited?
Limited civil.
Limited civil, okay. And if it is above $25,000, would that go to an unlimited civil?
It should, because it's based on what the case was. So theoretically, whatever courtroom or department your case was in, your claim of exemption was going to be heard in. So
besides claims of exemption, are there other any other defense? I mean, are you able to attack the underlying judgment?
So again, most judges, because it's a claim of exemption hearing, it's not a motion to vacate, it's not I shouldn't have been sued. Most judges, I can't speak for all of them, I've only been in front of a few of them in Orange County and LA, will say, I can only address the claim of exemption in front of me. I can't, if you have an issue with the underlying judgment, you've got to bring a motion to vacate or whatever.
And what if it's like the wrong person? What if they say that I'm not that you got the wrong guy?
That is such a great question. We have had this. It's hard because it's not a claim of exemption then. So that is a whole, I'm so glad you said that's come up several times. Names are similar. We've had people who are getting garnished because someone else used their social security number to incur a debt. And since they're employed under that social, they're getting garnished. So it's hard because the judicial counsel forms are somewhat limited in terms of what you can say. So there's on page 2 of the financial statement, there is a box that says any other facts that support the claim of exemption. And what I would put there is, this is not my debt. Someone else is using my social security number. I didn't incur this as, whatever. I mean, the box is about, you can't see my hands. It's about an inch. So
I'm going to just jump in. I think this is great. It's a lot of detail. Julia, I know you have a question, and then I think what we should do, because we've got to get through car repossessions and utility setup. And Abbas, I'm hoping maybe I can turn to you to take us into one of the next topics. But Julia, why don't you start with your question?
So I had just more of a process question. When you do the intake, who are the attorneys or who is meeting with the client?
It depends. So we have a paralegal in our unit who conducts most of the intakes, but when it's a claim of exemption, we're actually doing the work at the time of the intake. Other cases will do the intake and then do an investigation, but because a claim of exemption or a response to a complaint are so quick, we're usually doing them at the same time. So the paralegal starts to get the intake information, and then the attorney comes in to help fill out the form.
So then after she does the intake, or he as a paralegal, in terms of creating the final document for filing, is that generally done then by a non-lawyer?
I think it's a collaboration. So she'll put in sort of the things that she can, like the name, the address, the spouse, the household expenses, but especially when we're talking about the income and the payroll deductions, we try to have the attorney do that just to make sure that we're getting the correct information. And then the section on the page 2 that has about, are there any other wage orders? Are there any other facts of support? The attorney is going to fill that out because they have to go through the analysis.
And so then the final thing that always requires an attorney is the appearance in court for the relief that is sought.
That would be ideal, but a lot of times people are doing the claim of exemption hearings in poker.
Okay, thank you.
And then Leah, can I just ask you, have you guys already talked about bank levies, or is that a different? Because as I'm talking about wage garnishments, there were some questions that I think apply to bank levies, but I didn't want to get.
Yeah, we haven't discussed that. And that I did have a question too, Leah. One of the exemptions that can be raised if the source of the money is an exempt source. For example, if it's a retirement benefit, isn't that exempt from enforcement?
Yes, so that's going to apply in the bank levy because it's not a wage garnishment. So that was sort of where I was when Amos was asking about other defenses. Right. I didn't want to get into those because that's for bank levies. But yeah.
But they can't levy against Social Security benefits, and they can't levy against any payments that are coming in the form of a retirement benefit,
disability, right? Veterans benefits, Social Security, but it has to be traceable to them. So if someone has commingled their bank funds, like they have Social Security direct deposit, but then they got to give for $50 and put it in there, the bank will then release the funds, and then you have to do a claim of exemption to get everything except that $50 back.
Okay, thank you.
Mm-hmm.
Great, thank you so much. Abbas.
Hi, thank you very much for the opportunity, everybody. My name is Abbas Kazaronian, and as a matter of introduction, I'm on the board of Consumer Attorneys of California. I'm also a professor of law where I teach consumer law at California Western School of Law. And I run a 100% consumer protection law firm where I've litigated over 10,000 consumer protection cases. As a preliminary matter, I think it's a very narrow way to look at these areas by just saying, hey, how do you practice within the realm of wage garnishment or repossession? Because the way I practice law and the way most consumer attorneys practice law in this particular area is when I get a client, for example, when it pertains to, let's say, wage garnishment, but it also applies to, repossessions or anything like that. I try my best ability, and on probably over 80–85% of the time, I try and look for ancillary and companion consumer statutes where I can put the debtor and the consumer and take him out of a position of being a defendant and become the aggressor and the plaintiff using other kinds of statutes. And in order to be able
to... May I?
Yeah.
One issue we're struggling with is harassment by creditors, which we're considering for inclusion, but we haven't made a final decision.
Yeah.
And I'm curious, how often are those asserted as affirmative claims under the Rosenthal Act? And how many times are they asserted as a cross complaint to a collection action? We're trying to get a sense of those type of procedural issues.
Mr. Fleischman, I'm so happy you asked that question. That's a phenomenal question. And that was really...
No, credit goes to Amos, not me.
Okay. So that was going to be my next point. Every single category that you have before you today is in some way, for example, covered under the purview of the Rosenthal Act, which incorporates at 1788.17 of the Civil Code, 90% of the Fair Debt Collection Practices Act. And so, Justice Thomas, in a majority opinion in a case called German versus Carlisle, said that the FDCPA is a very, very complex statute. It's an extremely difficult statute to understand, but if you do understand it, you can use it as a sword rather than as a shield in being able to defend these cases. So yes, ma'am.
I just have a quick question, and I'm sorry to interrupt your talk, but this is a threshold thing for me. Do you think that this kind of practice lends itself to being something that paraprofessional should be given as a responsibility? Or what is your opinion in terms of how we could utilize these kinds of legal problems and make them suitable for a paraprofessional to participate in independently of working under attorney?
Thank you for that question. And the answer is no, I do not. And the reason for that is that I don't think you'll be able to do service to consumer if you are channeling in a tunnel vision manner into try and basically go through the process of a wage garnishment. You have to have knowledge about things like the Telephone Consumer Protection Act, the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, the Reese-Levering Act, the Rosenthal Act. And only if you have this kind of arsenal and weaponry can you take the consumer out of being a position of a defendant into the position of a plaintiff. Furthermore, what I do is the client is in state court in majority of the time when they are dealing with wage garnishment. I specifically go to federal court and file my case under the FDCPA or the FCRA or the TCPA under federal jurisdiction. Why? Because the attorney's fees provision that we have available to us under the majority of these statutes are a massive weapon for the consumer, where the debt a lot of the time gets negated and washed away in the underlying case, and then the consumer manages to put something in their pockets on top of that in the federal case. Second, because an attorney is an attorney, they can ask for attorney's fees, which is one of the major weapons these statutes carry with them. A paraprofessional does not have that weaponry because they're not an attorney. So they can't be asking for the attorney's fees, which is the weapon that these statutes are armed with.
Abbas, can you go back to my original question about affirmative claims versus counterclaims?
Sure. So in a case of, let's say, a wage garnishment, for example, the first thing that I always look at is like the interest rate that's being applied. Can we set aside the judgment? Was the right person served? And I use all of these as weaponry to be able to file. And again, if it's a Rosenthal claim, it would be a counterclaim. But if I can get it into federal court, I will put the counterclaim in federal court. And kind of putting in conjunction Mr. Fleischman's question and Ms. Brynelson's question, federal court is a very unforgiving place. Unless you know what you're doing, you're going to get punished. it doesn't have the same flexibility and elasticity as state court. So you have to know not just the substantive law, but procedure. The federal rules of civil procedure are very unforgiving. You need to know what you're doing, otherwise you can lose a good case on procedure. So going to Mr. Fleischman's question, I use that on a regular and systematic basis. Over 80% of the time, I can use these situations to be able to bring a counterclaim or an affirmative claim on behalf of the consumer. Yes, sir.
So one thing our committee has concluded, based in large part on an opinion from the State Bar's General Counsel, is no matter what we do, we will not be able to regulate the practice of law in federal court. So if we approve paraprofessionals, they will not be able to practice in federal court. So because of that, we have determined certain things are off limits, like bankruptcy as a simple example. What I hear you telling me is if we approve paraprofessionals in these areas, they're going to be losing significant weapons in their arsenal because paraprofessionals will not be able to assert the federal claims in federal court. Or is it just a venue issue?
No, I think there will be like, first of all, they have to have the ability to issue spot these things. But even arguendo, assuming that they issue spot, at that juncture, they're going to be hand-tied, not being able to go to federal court and do an effective job. And in another area that I think, kind of related to this is what we also look for are patterns that are systematic from creditors and debt collectors that are doing things like in a not an appropriate manner. Like Portfolio Recovery Associates is the second biggest debt collector in the country. In a case called Heathman versus Portfolio Recovery, it was a wage garnishment establishment based upon an unfair judgment. And it was the pleadings that we used to be able to assert a class action. A paraprofessional doesn't have necessarily the periphery of an understanding of Rule 23, which is the class action mechanism in federal court. And so what we also use is use these test cases on an individual level and then expand on them and file class actions. Now, if a paraprofessional was doing that and missed that class action, it's not just that one consumer that is being hurt. It's all those consumers that will be in the putative absent class members that would also being hurt, because that claim would not be being brought forth. Because again, it goes back to the issue of A, issue spotting, B, having the arsenal and knowledge of all these ancillary statutes, and 3, the ability to practice in federal court.
I'm gonna jump in because this is sort of exactly what I was hoping to avoid. I see your hand is raised, Elizabeth. Julia, I realize you asked the direct question, but I think we end up hearing a lot from speakers about their opinions as to whether or not paraprofessionals should do the work. And it's been hard to get through what the actual work is for these remaining case types. And I completely appreciate the passion, but I just don't want to forget that the data shows us the vast majority of people in these cases are unrepresented. So if we're thinking about whether everyone's going to be able to hire an amazing law firm or everyone's going to get a paraprofessional, those aren't really the two paradigms that we have.
But I agree, Ms. I totally agree. I understand what you're saying, but I really don't believe that this is an access to justice problem. This is a lack of education problem. Most of the statutes that I have just mentioned, enable to protect consumers, don't require them to pay for an attorney. They can get an attorney for free. If we spend the resources that we are spending in this committee right now in educating consumers on these statutes and what kind of rights they have, you will find an exponential increase in people actually hiring lawyers. It's just that they don't know they can get a lawyer and not pay for these lawyers. That's the issue.
Okay. If I can just do two things. In terms of the data, we have to remember that there are a lot of organizations who help people in pro-per. So even though they might show unrepresented, they may have had some help. But the other thing that I just do want to bring up is part of the process that I think we do have to remember is this idea of personal jurisdiction. Because if the underlying judgment is invalid because of a failure of service and someone goes into a hearing, they may have waived personal jurisdiction. And so if you don't catch that before and do a special appearance or do a motion to quash, in conjunction with the wage garnishment claim of exemption hearing, you may have taken away a very valuable tool for the judgment debtor to say, the court doesn't have personal jurisdiction over me, because the response is going to be, yes, they do. You went in and you asked the court to do something. So you're done. But I understand that we want to keep the facts going, but I also want to acknowledge that the procedure is very much entwined with the substance, and there are so many possibilities of having a paraprofessional who's just filling out a form and maybe knows a little bit to put the consumer in a much more difficult position to actually assert their rights in the future. And there's also just, I hate to use the trope, but you know, it's stronger coming from an attorney when you're threatening an FDCPA or a Rosenthal action because they're collecting on an invalid judgment or they're representing to the court in a memorandum of costs that was the subject for the writ that the judgment is now 10,000 when it really, when you do the math, it's 2,000. So I do want to give you the facts, and that's why I'm trying really hard, but I do want to acknowledge what Alice is saying and what other people are saying, that they are intertwined. We can't really separate them if this committee is going to make the most, the best decision for unrepresented individuals to really meet the access to justice issue.
I just wanted to say that I put in the chat that I agreed with Leah. A lot of times our questions are asking people for their opinions, and I find it really much more helpful to learn about the facts so I can envision, you know, what it is that a person would be doing or wouldn't be doing, and whether there's a justice gap or not. I mean, we are operating with the understanding that there was this justice gap study, and that this is the task that we're to do, which is to investigate and collect the facts and make a recommendation. If we were to collect opinions, then, I mean, we're just going to be getting a ton of opinions. So I don't have any factual questions at this time, but I wanted to say I definitely agreed with Leah's approach at this point.
Let me ask the subcommittee members with respect to, I think we covered wage garnishment. I'm not sure we covered bank levies fully at all. There's car repossession, and there is the utility shutoffs. With respect to any of those issues, do you feel like you have a good handle on what the actual work involved is? Carolyn.
I would like Abbas, I think he had some points to bring up with regard to, at least with the auto repossession and the Rosenthal Act. So I'm not sure we covered that. There was also on utility shutoffs. I didn't understand if that was limited to actions against the utilities and not including landlord-tenant, but we can probably discuss that later. But on the car thing, I was hoping we might hear a little bit more.
Sure. Thank you, Mrs. Shining. And respecting Judge Yu's comments as well. Unfortunately, it's very difficult to give you a car repossession factual pattern of how it goes from A to Z. And I think Ms. Gonzalez, through her experience, will also probably adhere to that too. In the regards that every case is different. So when a car repossession case comes into my office, the very first thing I look at is the conduct that was carried out before the repossession, the representations that were made by the creditor or the debt collector in the repossession. You get a lot of times where the representations were made as if you pay X, then you're going to be good for another month. They pay X, which is less than the monthly amount, but then they go repossess the car anyway, which would be a violation of the Rosenthal Act. And one of the things that separates the Rosenthal Act from the FDCPA is that it includes the collection of property, and obviously repossession is repossession of vehicles. You have to look at the notice requirements to see if the Reese-Levering Act is invoked or not. You have to look at the letters, whether they were sent by an attorney or whether they were sent by an independent repo company. Because if it was an attorney, that triggers the FDCPA. Are the right notices being sent? And so to answer your question, how do I practice helping a consumer in a repossession case? It's a factual question. It's a case-by-case analysis. Is, again, going back to the arsenal of statutes that we have before us and saying, what is it that we can use to put the consumer in the best position possible? And unless you have knowledge of all of these statutes and how to utilize them in the best way, you cannot do the job that you are being asked to do for that consumer. That is how you represent a consumer. And maybe Ms. Gonzalez can speak to this, but that is how I do it. You can't use a cookie cutter methodology in helping consumers in a repossession case.
Thank you.
I think, I'm sorry, I raised my hand. Is it okay if I jump in?
Yes, yeah.
I think to answer Ms. Gonzalez's question, it's not just the car repossession itself, but I think what happens before and after. And I just found and I'm sorry, Mr. Kazaranian?
Yes, ma'am.
Thank you. I found what he said actually very helpful to know what he has to look at, what he has to consider, those factual acts or tasks that must be taken. And so I know when I was an attorney, there was the Rudder Group practice guide, and there were checklists of things to do. For those things that you described, is there a checklist that guides attorneys as to what they must consider? Is that something that you just gather through experience or going through a CLE program? How did you know to do all those things?
It just comes through experience. To become a practitioner in this particular area, you know, it takes a certain amount of expertise. The only treatise that there really is on this is the NCLC manual, which is the National Consumer Law Center. And I'm a frequent speaker at their conferences on these particular issues. But the checklist is kind of also dependent upon the fact pattern. And there are some fact patterns, you know, it's kind of somewhat analogous to 1983 cases, is that you look at other cases that have happened before, with the exception that there's no immunity. But having said that, the FDCPA and the Rosenthal Act have catch-all provisions, which are very elastic in nature. And so you have to be very creative as a lawyer to say, is like, can I make this act fall under deceptive, unconscionable, false representation? Because, and those are also looked through the purview of the least sophisticated debtor. And that is not a reasonable, prudent person standard. The least sophisticated debtor is deemed the most gullible of our society under the Ninth Circuit standards. So it's also irrelevant what your mental state of your client was at the time of the alleged violation. It's what that objective, most gullible person in our society would have perceived. And basically, like, you accumulate all of those facts, and under that case-by-case analysis is, can I carve out a violation here? And so that is the way I would approach it. And really, the only manual, as you would put it, is really the treatise that's put out by NCLC.
And does NCLC have checklists of things to do like Rudder would have?
Not really. What NCLC does is tell you what there is of black letter law. And unfortunately, under the FDCPA, Rosenthal, Reese-Levering, these are all fairly new statutes. There's a lot of gray area and undecided case law. That is why a lot of the case law that we actually bring forth under these statutes make their way to the appellate court. So, like, I mean, I've got one case right now where I've been to the Ninth Circuit. I'm about to go for the third time on what was really a $5,000 case, but now it's turned into a $500,000 case because of the attorney's fees, because of the complexities and the gray areas. And so what NCLC does is it gives you a black letter law if there is black letter law, and it gives you what suggested law is with the caveats, and then the case law under it for you to analyze. And that is really the best you're going to get.
Okay, thank you.
If I can just add in terms of the facts, one of the things, and this also applies to wage garnishment, I think it applies to most issues, is when you're doing the initial intake, the client doesn't necessarily use the right words. So if someone is being trained for car repossession and the client has turned in the car, surrendered the car, or it's been left at the dealership because it was supposed to be repaired, but then it wasn't, and there was a dispute, and the car was sold. I think the concern would be, how do you train a paraprofessional to get the information from the client to determine what the issue actually is? Was it a car repossession? Was it a surrender? Was it a lien sale? What was it? And then from those, what happened? Was the notice of intent properly filled out? Was the notice of deficiency properly filled out? And that's why I asked the question about, are we just talking about the procedure of repossessing the car or before and after? Because as was stated, if the notice of intent can be great, but then the notice of deficiency is wrong. And so it is an issue spotting thing, but it's also getting information from the client. I mean, I can't tell you how pulling teeth it is to get information from clients that, you know, we push and a lot of times it's like, I don't know, or I don't have it. I don't know, I don't have it. And then it's, you know, the 10th interview where they're like, oh, did you mean this? Yes, that is what I meant. Mm-hmm. So I think there's also a time intensive situation to try to get the facts to determine what issues exist. That my concern would be, how do you train someone to figure that out? And there are, I only mentioned like 3 things. There are so many other things that could come out into a notice of deficiency or a collection judgment. And then you're getting into the collection side of things and trying to prepare, because there's things you can do before the lawsuit is filed to help you defend it. Because, you know, if you write a dispute letter, it's really hard for the creditor to win on an account stated or an open book account because you haven't agreed to it. And so there's just little things that should be done as part of the process that you learn by experience and by figuring out if it applies. So I just want to make sure that we're aware of those other things, and I'm happy to get more specific. I know we're running short of time, but
we've got a couple of subcommittee members with their hands up. So Stephen Hamilton and then Amos.
Yeah, boss, in the repossession cases, which federal statutes or acts will you use either as a defense or as part of a counterclaim?
It depends if a law firm is involved in the repossession or a debt collector. If it's a debt collector or a law firm, you can use the FDCPA. And of course, if there is, you have to look at the telephone calls as well. If they're violating the Telephone Consumer Protection Act, that's obviously a federal law that was enacted in 1991. Then you, outside of that, you've got just California statutes like the Reese-Levering and the Rosenthal. But of course, if you have a class action that you've spotted under, let's say, the Reese-Levering, and you've got diversity, you can under CAFA file it in federal court as well. Whereas the Rosenthal, you probably cannot, because it's got a statutory cap of $500,000. But those are the examples of federal statutes that I would potentially use as well.
And how would the consumer be harmed if they didn't have the ability to take advantage of the federal statutes in those situations?
In a massive way. So let's hypothetically say you have a debt collector that was involved in a repossession that illegally called my client 100 times. They'd be leaving $50,000 on the table, potentially. And most repossession cases and wage garnishment cases, you're dealing with from amounts of less than $3,000. Now, admittedly, if it's a stale debt and it's accumulated post-judgment interest for 10 years, it could be $10,000, $15,000. But don't forget, if you've got an attorney provision as well, like something like on an FDCPA case, that's unlimited. So, and you know that the debt collector on a stale date that's collecting it paid pennies on the dollar. So to them, that's not that much that important. So having an innate knowledge of the debt collection industry is very, very important in able to be able to deal with these people, not just an understanding of procedure and substantive law. All of these things together, and obviously experience and knowing litigation counsel on the other side. And the final point as to that I'll make as well is that even though, like, you know, the idea here is to discuss paraprofessionals representing consumers, one thing I can pretty much guarantee is that the banks are never going to use paraprofessionals. So these people better be equipped, because they're going to be dealing with, you know, with top 50, top 500 law firms on the other side of the V. So that is also very, very important. But I hope I've answered your question, sir.
Thank you.
Amos.
Thank you. So this is very helpful. I hope, I'm sorry it's running long on this stuff, but I find this detail from practitioners very helpful. And I have 2 questions, and really for either of you. I think one, in my mind, I'm trying to understand if there is a big distinction between the normal debt collection case where you represent a consumer versus an auto repossession case. So in other words, if a paraprofessional, let's assume, can handle a debt collection case, can file counterclaims in state court under the various state or federal consumer protection statutes, is trained in understanding what those laws are and issue spotting, is the auto case, are the auto cases more different enough and more complex enough that they wouldn't also be able to handle those types of cases? Or is it really the same, you know, it's how many times did they get called? You know, is it an attorney or a debt collector? Is it, you know, and are there different statutes that deal with, you know, the auto possession, repossession type cases?
Yes, I would say, and Alice can correct me if I'm wrong, they're different. I mean, the procedural of someone has filed a debt collection and limited civil, that, you know, once it's filed, the procedure of you've got to file a response, all that, yes. But there are so many other things at play that are not necessarily at play in a regular old debt collection case. I mean, I think reslevering is huge. I've been working on these cases for 5-6 years, and I learned something new about reslevering almost every time I get a case. I think I put in the chat the 1632, the language translation issue. It's very rare that the credit card is negotiated. You know, someone just fills out an application, but the car purchase is often negotiated in a completely different language. And there's a whole other route that you can take under 1632 to rescind the contract, not just get attorney's fees and not just, you know, but to rescind the contract. And that's really helpful because they already have the car. So now you rescind the contract and then you're also adding on the other things. I do think that they're pretty different.
If I may also, like, I concur with Ms. Gonzalez, that you're dealing with different statutes and procedurally it's very, very different. And again, I just want to reiterate the fact that if you have a counterclaim without the use of attorney's fees, I mean, when there's a counterclaim, you know, let's say you have just a mere statutory violation under the FDCPA, your best day for your client, because the statute allows for up to $1,000, period. That's not going to do you much trying to counterclaim a $5,000 or $3,000 debt. Whereas if you've got 1,000 plus attorney's fees, that's an uncapped amount of money. And therefore you're in a very, very different tactical situation. But you know, overarching answer, yes, sir.
And my other question actually is about attorney's fees. So, and it's a two-part question. One is the attorney's fees statute one way or both ways? So if a debtor files a claim seeking, you know, violation of their rights and attorney's fees, if they lose that claim, are they subject to paying the other side's attorney's fees? And well, let me do that one first.
Okay, so it depends on the statute, but the Rosenthal and the FDCPA are one-way shifting. The costs are both ways under a Supreme Court case called Marks, but that's just the cost. You know, FDCPA cases aren't that expensive, but the attorney's fees, to answer your question, are one way. And most, not all, most remedial statutes tend to have a one-way shifting statute, but obviously it depends. And the TCPA does not have an attorney's fees provision. California 632, which is actually a penal code, by the way, we use a lot as well. That does not have a fee shifting provision, but one violation creates a $5,000 violation. And so just one court can get a debtor out of trouble, for example. So
my final question, and thank you for your patience, is the attorney's fees would be available in state court as well as federal court. It's just that your concern is a paraprofessional might not be entitled to seek attorney's fees. Is that right?
Absolutely, sir. But I just don't understand how they would be, like, under statutory rules of statutory construction, a paraprofessional would be entitled to attorney's fees.
I do also, if I can just, I know no one's asked the question, but I just do want to point out that at least for us, a lot of our cases end up settling. And so there's a whole other issue in terms of figuring out a settlement that, especially for low income individuals, doesn't mess with their means tested benefits like their earned income tax credit, Social Security, supplemental Social Security, tax, like all of this. So that's something else that you want to consider, because settlements are really important in cases like this, but they're important in even more so with low income debtors, because a settlement can impact, because any quote unquote forgiven debt, if it's not under a disputed debt doctrine, which is a whole other thing that we can talk about, but we don't have to, that counts as income. So if there's a $20,000, you know what, you don't owe it, never mind, we're scared of you and we don't want to pay attorney's fees. Now that debtor has a $20,000 income that they didn't have. They're losing their earned income tax credit. They're learning their Cali EITC. They're losing their SSI. They're losing their Medi-Cal. So that's also huge to think about when resolving the cases, because usually they resolve, at least in my experience, maybe it's different for others, but there's a lot of settlements happening, and they can be very dangerous if they're not properly investigated and written in favor of the client.
Wow.
So it's 6:04. We have 4 people right now who have identified themselves as wanting to make public comment. We've also got to leave some time for just your deliberation, review of the decisions you've made so far, and then a little bit of time for deliberation. So unless a subcommittee member has a burning question, I see no, I don't see any hands up. I'd like to move on to public comment, and Elizabeth and Abbas, you're welcome to stay on. You won't be able to kind of participate free-flowing with the subcommittee as you have been once we move on. And I really want to thank both of you. And I'm sorry if I interrupted you a lot. I was just trying to keep us on track and moving along. So thank you.
That's okay. I know we didn't talk about the utility shut-off, but I do think that Turn, I think maybe you guys have had some experience with them. I think they're really going to be the ones to talk to you guys about this, because I don't handle a lot of like individual utility shutoffs, and there's a whole advocacy group that is probably best suited for that. Just saying that out loud.
Okay. All right. So we've got to actually have a lot of people with their hands up now. I'm going to move on to public comment. I'm going to, yes. And I'm going to make these 1 minute each given our time. So Mr. Stempler, please proceed.
Yes, it's Robert Stempler. I only have a minute, so I will be brief, of course. I really appreciate everybody, what you guys are doing. A few points that Abbas made. Actually, I know Abbas from the NCLC and National Consumer Law Center, NACA. And having a paralegal, a non-lawyer, litigate cases in the affirmative, litigating affirmative claims against a debt collector who's going to hire some of the best lawyers in the country, it can only wind up in costing the debtor, the consumer, not only the fact that they might lose and have to pay the other side's cost and possibly an attorney's fees, but how does just because a person can spot an issue does not mean that they can present that issue in court appropriately such that the plaintiff prevails and gets what they are entitled to under the law for actual damages or compensatory damages. The other thing I want to say is paralegals are not inexpensive. They're extraordinarily expensive. Many times I've been contacted by paralegals, and not by paralegals, by consumers who have paid for a paralegal, and they paid the paralegal for piecemeal work more than they would have paid me for the entire matter.
Mr. Stempler, your minute is up. Thank you.
Thank you.
All right, next we have Olivier Tellier.
Hi, good afternoon. My name is Olivier Tellier. I'll skip my credentials, and I wanted to address one of the things that was discussed today, because this is in relation to the justice gap study. And I think one of the important points, and one of the points that the committee has not been discussing, is that if you look at the statistics, 31 as to any people that have issues, 31% are unsure if it was a legal issue, 31% have decided to deal with problems without help, 16% are worried about cost, and 15% did not know where to look, and 14% are afraid to pursue legal action. And so the one component here that relates to cost only addresses about 16% of the population. Now, the reality of it is, we can train anybody to do anything. And I don't doubt that paraprofessionals can learn some of the things that attorneys learn. But these things are going to cost money. And also, they're going to have to be insured. They're going to have to carry malpractice insurance. And they're going to have office costs. And therefore, in a very practical sense, if we're going to educate these paraprofessionals to do the job that attorneys are now doing, the cost of that education is going to be borne by the consumer. And without the ability of recouping attorney's fees, this will actually cost more money to the consumer than if we were to leave the system as it currently is. Thank you for your time.
Thank you. Ira Spiro. Ira?
Yeah, can you hear me now?
Yes.
All right. I think this is probably the case, but Abbas and Elizabeth, who are doing such great work, could correct me, I think. I think that there is a significant percentage of people who are facing debt collection who don't have Fair Debt Collection Practice Act claims and or Rosenthal Act claims, and who cannot get lawyers to represent them, partly because they don't have the affirmative claims. Because I think there's a significant number of people in that category, I think paraprofessionals, as I've said before many times, to have a paraprofessional is better than nothing. And because they can't get attorneys, better paraprofessionals are better than nothing. And I think this applies, though, only to a limited civil case, although maybe not.
Ira, thank you. It's been a minute.
Yes.
Thanks. Stephanie Carroll.
Hi, can you hear me?
Yes.
Hi, this is Steph Carroll from Public Counsel. At the last meeting, in-court advocacy by paraprofessionals in limited civil debt litigation was pushed through at the very end of the meeting without, I would say, any real debate. I urge the committee to reconsider that, especially in the light of comments from Abbas. I'd like to thank Abbas. I don't think anyone else has made the case so clearly of why paraprofessionals should not be allowed in court in the debt collection space. I'd also like to add that there was some discussion at the last meeting about making the agenda more transparent so consumer advocates knew what was coming up for comment. The agenda for today is A, public comment, and B, discussion of subtopics for consumer debt practice area. That is not transparency. Lots of advocates are unaware of these meetings entirely, and as a result, there is a lack of wide-ranging consultation with practitioners working in the area. Also, we're being asked to comment in a vacuum without any identification of guardrails like level of education, malpractice insurance requirements, fee caps, or enforcement mechanisms. I urge the committee to stop and make time for further consultation. I did have a good client story from today, but I realize I don't have time. I urge the committee to think more.
Thank you.
Ms. Carroll, as a committee member, I just want to say I share your concern about the detail of the agenda, and I've raised that with staff. I just want you to know your comment did not go unnoticed.
Thank you.
Okay, Mr. Shemtop.
Hi, good afternoon. Can you guys hear me?
Yes.
Hi, my name is Attorney Michael Shemtube. During the last downturn of the economy, in a one-year period, I filed nearly 2,000 bankruptcy cases and dealt with an extreme amount of volume when it came to debt consolidation. I noticed that 25% of the time I was taking over cases from essentially paraprofessionals who made mistakes and maybe lost people's homes, jobs, cars, because in the bankruptcy world, there's already, I guess you can say, quote unquote, paraprofessionals like paralegals that are working on their own to handle cases. But I think one thing that we have to keep in mind is that we should make no question about it, that we've actually gone down this route before during the last downturn, where we allowed, whether we purposely or unpurposely allowed paraprofessionals to work on loan modifications. And they started working on loan modification, and we saw what kind of disaster that was when people lost their homes in the thousands throughout the nation. So I'd like us to not forget the past in regards to what happened with loan modifications. And I think going down this route is something where consumers won't be protected. And if I can say one last thing.
No, you can't. You can't. I'm sorry. Thank you. And I want to just talk to the subcommittee. We have about 1, 2, 3, 4, 5 hands remaining. That will take us close to 6:20. Do you want to keep going with public comment?
I vote to do it as you're keeping it nice and tight, Leah, and I think there's some really important things we're learning here.
Is that even an option, Leah?
Yes, it is an option. Brady's on. He can tell me if I'm wrong, but I believe that we can do that.
I'd like to hear from Mr. Stevens.
Okay, I don't think we can handpick who we hear from. So let me go ahead then with Claire, Johnson, Raba.
And then before the next
Hello.
person, can we just do a caucus to see if we have any, I mean, we might all be on the same page and then it's just sort of moot, instead of staying here till 7 o'clock.
Okay. Claire. You're muted.
Sorry, I was still muted. So my name is Claire Johnson-Raba. I'm a clinical teaching fellow at the Consumer Law Clinic at UCI, and my research at UCI centers on debt collection cases. The Judicial Council of California, through the GIPSIS system, doesn't even collect information on the filing, disposition, or post-judgment collection of limited civil cases through the county courts. But my research over the last year shows that in the last 2 years, we had a record number of limited civil debt collection filings. This is indeed a huge problem. But that means that there are over 200,000 Californians every year who may be subjected to more harm by predatory or ineffective paraprofessionals. The risk for harm is great. Without a better understanding of what the current outcomes are for low-income and unrepresented consumers throughout California and an ability to study whether the paraprofessionals result in a better outcome, I really suggest that the State Bar put a pause on this project until we're better able to collect data statewide on debt collection lawsuits. Unlike in Utah, where the regulatory sandbox is proceeding in collaboration with the University of Denver's IALS and the court's committed to empirical study of the impact of changes, I think this is proceeding wholesale without an ability to study the impact of these changes. I strongly suggest that this project be delayed until we have adequate data against which to evaluate its efficacy.
Okay, Ms. Johnson, it's been more than a minute. I'm sorry. Thank you. All right, Judge Yu, I think you wanted to do a check-in. You're on mute.
A lot of us have been doing that today. I just wanted to do a check-in to see if we're at all at consensus.
Can Judge Yu, before you ask that, can we at least put a slide up that shows what you've decided so far?
Yes, please.
Okay, Linda, are you able to do that? I know I kind of want things on demand and they don't always happen. While you're doing that, I will say one of the issues with detailed agendas, which Linda has shared, is because these meetings are publicly noticed, we're required to post the agenda at least 10 days in advance. And as you all know, since you've been seeing us every week, we don't have a detailed agenda 10 days in advance. So here's what we've done so far. We have, and I think either Stephen or Steve, you indicated that we had not made a decision about creditor harassment.
Yeah, I had a genuine misunderstanding of what was voted on last week, and I don't want to get into particulars, but you know, I understood we were eliminating unlimited jurisdiction, and I was okay with that. I did not consider that vote last week a final decision on including creditor collection agency harassment. I just considered it, you know, one of the things we're going to consider limited to limited jurisdiction debtors. I thought what Erica had said, and if you recall, I made the motion and withdrew it, but what I thought Erica said was, for the 4 topics, can we agree to limit it to debtors and to limited jurisdiction? Now, Linda was kind enough to send me the link to the meeting, and Linda's right and I'm wrong. And if I need to make a 473 application at Judge Yu, I will. But I didn't consider that to be a final be-all, end-all on that subject.
Right, and of course, this still has to go to the full working group. It is, I think Judge Yu has aptly characterized this as a funnel process. So maybe it should say this is all that's remaining of that particular issue. So I think here's where we are. And the only other, Linda, I don't know if you have a slide that shows the related general civil decision. Yes, I wanted to bring this up because this came up, I think, in Elizabeth's question. All I wanted to do is refresh your recollections as to what you've done already, and then open it up to the conversation. And Linda, maybe put it back on the previous slide. I'm not sure.
I'd like to explain to this committee what happened in general civil to get to that result. And Linda, could you put that slide back on? And Erica, it was just you and me. And if I say something wrong, I'm inviting you to interrupt me and let's get it. But
why do we need to do that?
Also, I just really quick before we go again, we have several people who are from public service entities, legal services. I hope we can get a chance to re-invite them back. I just want to thank them for being on the line. I know their time is really precious and thank them for their service.
Thank you, Carolyn. But Steve, why do we need to do that?
Because it has a direct bearing on what we're discussing now. Because some of the decisions you and I made have an impact on the 4 current topics. If you don't think there's enough time and you want to defer it to later, that's fine. But you asked for a general sense. My general sense is we should be greatly limiting these topics, these 4 topics, including harassment by creditors. So if you just want to take a straw poll and see where we're at, that's fine. But at some point, if we're going to be talking about the merits of these, I need to explain to this committee what happened in general civil, how we got there. For example, we never ever considered affirmative claims for relief by debtors.
Yeah, I was asking for a straw poll because I think I'm at the same place you are and Carolyn. So I'm not sure that there's going to be too much debate. And so I'm just hoping.
Can you make a motion, Erica? Or
no motion, straw poll.
Let me just pause. If you're suggesting that you want to change the general civil recommendation, I don't think we can. Oh, okay. I think that's okay, but I think that's what Steve's recommending, Judge Yu. So
no.
maybe. Oh, you're not.
There's one part of the general civil recommendation that I will discuss with Erica that I think may need to be done. But let's take a straw poll now on these 4 topics. Do we think they should be in or out? If the results of the straw poll are clear, we've saved a lot of work. I think that's what Erica's saying.
3 topics.
3.
No, I want it to be all 4 because I, again, did not think that vote last week was intended to be the be-all, end-all.
But it wasn't. It was a funnel. The vote was taken. And just because you change your vote doesn't mean it changes everything. And it's not fair to have everyone go back to that when we didn't have notice that we were supposed to go back to that.
Well, you know, Erica, I think the way the funnel process is working is we can take things out. It's not that we're adding something back in.
No, I'm not saying we can't address it, but I don't think we should address it now because nobody was told that we were going to be talking about that now. It's
okay, then I'd like to put it on the agenda for next time, maybe not the formal agenda, but I'd like to revisit the creditor collection agency harassment next meeting so everyone's aware. And let's take a straw poll on these 3 issues. Should they be in or out?
And if we revisit it, I think that should be something that everyone agrees yes or no, and we should know what the vote was because it may not make a difference what your vote if you change your vote.
Well, I'd like to explain to people what happened in general civil.
I've been looking for that too, but we can vote on the 3 and then talk about the 4th.
We're not voting. We're just doing a straw poll to see.
So my straw poll is to eliminate these 3 categories. That's me.
Even utility shutoffs.
Yeah, I was going to say, I think we should eliminate car possession and wage garnishment. I'm not sure yet on utility shutoff, and I know we heard a little bit about that last time, or quite a lot about that. But I think I'm persuaded that the tasks that are involved, the expertise that is required to consider everything is something that attorneys should handle. So for car repossession and wage garnishment, I'm persuaded that those tasks would probably be best left to an attorney. And partly that's because I know for this general civil, we've already put stuff through the funnel. I think Julia had her hand up.
I agree with Judge Yu.
I'm with Steve as to all 3 because I believe I understand that utility shutoffs due to non-payment from the utility company go through the PUC. They have a special process. They also may be subject to arbitration. I think we heard from the Turn lady who said that there's multiple tiers of problems with those. So I don't think we're ready. I don't think California's ready to set that one up. We get a lot of other things to bite off. My straw poll is all three should be not on this time, not now.
Okay, Amos or Steve?
So I agree on car repossession. So I'm very convinced by the speakers that that is separate and different and complex. So I agree. Wage garnishment, I actually think it sounds like it's pretty straightforward judicial counsel forms. There's some calculations and some forms, but if it is limited to the wage garnishment as an add-on to the debt, you know, if we're already helping with, you know, debt harassment and debtor litigation, I think wage garnishment is a appropriate add-on to say, you know, you shouldn't be able to garnish exempt wages, or if you're garnishing too much, and to help with those forms. So for the straw poll purposes, I think wage garnishment probably should be in, but it sounds like I'm in the minority.
Amos,
Stephen
where
Amell.
on utility shut off? In?
I
Or maybe
don't think
under
I know
some-
enough about it,
Right.
unfortunately.
Okay.
And Stephen Hamilton here. I'm agreeing that all three subtopics remaining to be addressed be excluded.
Okay.
So I would ask that any public comment not address car repossession, because I think we are all agreed on that one. So it might help funnel out some of the public comment.
So you'd like to go back to public comment specifically on the issues of wage garnishments and utility shutoffs. All right, any objections among subcommittee members?
Erica, are you talking today's meeting or future meetings?
Well, I would hate to have the public come back, although it's 6:25. And if Brady says we don't need to have all the public comment, I'm not sure if we need it.
And the only other thing I would say, what we could do with our 5 minutes is figure out what we're going to write up for you all to present to the full working group next week. That's another alternative use of our 5 minutes. So
Can I have a suggestion?
Yes.
I would like to limit the public comments to the remaining two. We make a motion and actually vote on removing car repossession, and then whatever comments need to occur amongst all of us.
Is that enough direction for how we write it up for the general meeting next week, and that the other two are still being worked on?
Yeah, and what we'll say is that at least one member of this subcommittee wants to bring back the issue of creditor collection agency harassment, and we can indicate that in the memo.
I think there's two of us that want to do that.
Okay, so
More than that.
There might be more.
Three.
Okay, so Julie, were you saying take public comment now also?
I would say take public comment on the two remaining so we can finish up this meeting, conclude it, and make our motion for a vote.
Okay, so Jenna Miara.
Hi, can you hear me?
Yes.
Okay. I'm a directing attorney at Bethzetic Legal Services, which provides free legal services to LA County residents, including on a variety of consumer issues. And I know my time is short, so I just want to say that Bethzetic has grave concerns about these proposals for all of the reasons that have been expressed by the experts and the other people who have commented before me. I really think this is a solution to a different problem, or it's not a solution to the problem that's been identified. People need education about the fact that they have legal issues, and we need to expand access to legal aid attorneys and paraprofessionals who are supervised by those attorneys. I have worked with paraprofessionals throughout my career as a legal services attorney, and they are an incredible asset, but they need to be supervised. The law is simple until it's not, and then it's very complicated, and only attorneys can figure out which of these wage garnishment issues need to be handled in a more complicated way than the judicial counsel form. And only attorneys can make sure that people are not waiving their rights through settlement releases or interfering with their taxes or public benefits.
Thank you, Ms.
I
Miara.
urge.
Thank you. Desiree Nguyen.
Hello, good afternoon. Can you all hear me?
Yes.
Hi, thank you. I'm the supervising attorney for the Consumer Advocacy Project with the Justice and Diversity Center here in San Francisco. We also serve low-income consumers, but we do not strictly enforce any eligibility requirements. We help consumers through trained attorney volunteers, pro bono services. these clients get help on a pro basis as well as full scope representation. Many of the wage garnishment issues that we've seen are able to be set aside because these people were not properly served, or it's a good basis for a set aside. If a paraprofessional misses this opportunity, that consumer has now completely lost their opportunity to set aside a judgment, and they live with it for the rest of their life because it's good for 10 years and renewable. So I highly encourage this committee to really think about the permanent ramifications that consumers face when their issues are put in the wrong hands. Thank you.
Thank you. Mr. Stevens.
Can you hear me?
Yes.
Thank you. Good afternoon, everybody. There have been a lot of comments regarding the details of how bad an idea it is to rely upon paraprofessionals to represent consumers in incredibly complicated consumer protection statutes, as well as the strategy and tactics involved in representing consumers. I'd just like to offer an overarching thought as I was listening to all of the comments. Practicing law is not about filling out forms or checking the right boxes or doing the right intake. If it was just about checking out filling out forms, frankly, we wouldn't need judges either. We could just submit the forms from the debtor and the creditor, and some algorithm could decide who wins. We learned in law school that the talent of being a lawyer is because you are creative, like Mr. Kazurian, who actually sees how statutes can be used to protect consumers and take an aggressive position. And that's my overarching thought about any thought about turning paraprofessionals into attorneys. Mr. Fleischman knows me from my medical malpractice background, and let me tell you something.
A minute is up. Ms. B. Latona.
Good evening. My name is Bilal Latona. I began my career at a nonprofit in South Santa Cruz County at the Watsonville Law Center. I want to specifically address the debt collection and harassment claims that clients have when they are sued. About 90% of my clients are monolingual Spanish speaking, and most of the time when they are sued on a debt that's either old or stale, if it goes to a paraprofessional, those people I liken more to debt settlement agencies. In other words, eventually over time, they're going to start settling cases for the consumer without really considering any of the merits. Justice, you talked about earlier, asked a question about where did I learn this? And like Abbas Kazarian, I learned it outside of law school, but also in law school. I went to Santa Clara Law. They have a great consumer program there, and I took several classes. So it takes time and years to be able to learn this area. And I don't think paraprofessionals are geared towards addressing the issues that they're going to find in front of them, specifically how someone can effectively assert affirmative defenses and also bring an affirmative case and at some point settle the case. It's been my experience in litigating these cases that most debt collection firms will settle a case when they realize that the consumer has a debt collection.
It's been a minute. I'm going to move on to Joanna Adler.
Hello, can you hear me?
Yes.
Great, thank you. So my name is Joanna Adler, and I'm a staff attorney at Public Counsel. I just wanted to echo my previous colleagues' concern about having paraprofessionals work in the debt collection litigation context. As Abbas definitely described, the legal issues raised in individual debt collection proceedings are quite varied, and each is governed by different comprehensive and complex regulatory schemes. And just as an example, we had an individual who sought our assistance for what seemed like a straightforward debt collection matter. We were able, however, to issue spot and identify issues relating to misrepresentations, fraud, unfair business practices, debt collection violations. We also discovered that over 500 other individuals had also been sued by the same entity in collections, and we ended up filing a class action cross complaint. So our concern is that a paraprofessional will not be equipped to spot these nuanced legal issues, have the understanding of the many comprehensive legal schemes involved, and then have the capacity to litigate these complex matters. And while I understand that there are individuals who are not being served, I don't believe institutionalizing a two-tiered justice system is the answer.
It's been a minute. Thank you. All right. It's 6:33. I think that is the end of our public comment. My understanding of what we are doing is drafting. Yes, Steve.
So of the 6 subcommittee members, 3 want to revisit the creditor harassment issue.
Yes.
I do not believe we as a subcommittee are in a position to make a full recommendation to the whole committee yet. I'd like not to make a report to the full committee for the next committee meeting, have another subcommittee meeting where we can hash these issues out. I realize that, well, go ahead, Leah.
What about a status update? I think as we're drafting, I'm thinking about family law. Some issues are what we've drafted. Some are recommendations. Some is just a status update. You know, it would be helpful, I think, just to sort of capture what's been discussed so far.
As long as it's clear that these are tentative only, have not been decided, and we are not asking for votes on anything at the committee meeting. I also would echo some of Carolyn's thoughts. I think we would need to see that report before, to give us enough time to edit it with enough time before the committee, all of which is why I prefer for there not to be a report. But if you want to call it a status report and we're all on the same page that we're not going to be voting, my concern is we get to the committee and things take on a life of their own.
Can I make a suggestion that it appears we all agree that car repossession can be voted on and funneled out, to use Judge Yu's terms? Can we not make, are we interested in making that vote today, Stephen?
Sure.
Okay.
I move to eliminate car repossession.
Sorry, also Steve, in our status report, we have excluded identity theft, unfair or deceptive lending practices, problems with credit repair services. So that should be part of the status report. I mean, we are making some headway.
That's fine, but what I don't want to have happen is to have the full committee vote yes on creditor collection agency harassment being in until this subcommittee has another chance to discuss the issue at length and have a discussion on it.
Can I make a motion to funnel car repossession out and to maintain that we are going to revisit the creditor collection agency harassment with no decision to be made in the full group, and we will conduct further meetings regarding wage garnishment, utility shut off due to non-payment, and we request that the full panel not vote on those included items until we meet further.
Well, so we don't want to include wage garnishment in the motion?
I think we're including it, that it's included until we talk further apart from the entire panel of the meeting of the working group. So what I want to reserve for the future, just to what Stephen is saying, is we don't want to take that included item to the full group yet, and we don't want to take wage garnishment or utility shut off to the whole group yet until we have one more meeting together. But that we would be willing to vote right now to eliminate car repossession as a topic to bring to the full group.
I second.
Okay, well, Linda or Araya, can you take the roll? Hello?
Sorry about that. I couldn't unmute for a second. Yeah, I will be happy to take the vote. Give me 1 second. Brynelson?
Yay, funnel car repossession out and reserve further discussion for the other topics.
Okay, thank you. Fleischman?
Yes, funnel car repossession out, reserve on the 3 remaining issues for later discussion with no recommendation to the full committee.
Okay, thank you. Hamilton?
I'm going to just say yes and not make a speaking objection.
Parkinson? Hartston,
Yes, thank you.
Shining,
Yes.
Judge Yu.
Yes.
Thank you. The motion carries.
All right. Thank you all. Anything else for today?
When is the next full committee meeting, Leah?
It's Tuesday.
Tuesday.
That's why when you said, make sure we have ample time to review.
Steve, there was a reason I asked that, because I didn't have my calendar in front of me.
Oh, I thought it was a rhetorical question.
No.
Not tattooed on your brain, Steve?
Well, I
We
think
should have
with
talked about
that
what-
vote, I think with that unanimous vote, we have the outline of what our update is.
And we'll get something to you. It's not that, and you know, we'll do our best. It'll be lean and mean, so there won't be much to object to.
I think there's something to be said for the overwhelming information we've received from consumer-oriented groups and associations over the course of the last 2 meetings. And I think that's why it's good for us not to weigh in yet till we can really have, we're being denied the opportunity to have really an open discussion because we've had speakers at the last 3 meetings and not been able to dialogue, so.
No speakers at the next meeting, subcommittee meeting.
I agree with that. I'm glad that we're chipping away some topics that we all agree on so that we can demonstrate that we are moving forward.
So we don't have an incomplete on our report card?
And we will show you at the next meeting, first of all the data that you've been asking for. We did have it for today, but also the ad campaign that's gone out to get consumer voice. Because while I hear you loud and clear about not wanting speakers, I do notice that there are no, there hasn't been one topic that lawyers, either legal services lawyers or otherwise, have advocated for with respect to inclusion in the paraprofessional program. So I think we all should be noticing that as well. Every legal area is unique and very complex when it comes down to that decision about inclusion or exclusion. And what we haven't heard from is true consumers. Judge Yu has raised that up to Donna, and we did finally launch today a Facebook and Instagram campaign to try to get real consumers. So maybe we'll hear from them at some point.
What accounts are those through? What state bar accounts?
State bar.
The state bar Facebook and the state bar Instagram?
Yeah, we're gonna show them at the.
It's actually, they're not running on, like, for people who follow the state bar, because again, there are not.
I don't know how it works.
Following the state bar, they're targeted to specific groups.
Oh, you've actually done paid ads?
Yes.
You've actually made ad purchases through Facebook?
Yes.
Linda, I think that's a great idea, but I do want to share with the committee, I find very insightful the comments from the Betsetics and the public councils of the world. I mean, I can understand why certain attorney groups take positions against things, but I'm just telling you, I usually think public counsel and Betsetic are acting from a, how can I put it, more pure position than perhaps other groups. I see Amos smiling.
I will also add that I think many of the comments that we've received in this subgroup have to do with the concerns that I have tried to raise previously, and I will continue to raise. And I think we need to spend time on consumer protections and education and licensure. My understanding is that's not what this subcommittee is doing. We're trying to look at tasks. If there were a program, what tasks would be appropriate? But I do think we need to make sure we have sufficient time to hear all the public comments about concerns and ways to potentially build in consumer protection.
And on the meeting on Tuesday, on the agenda is revisiting the work plan, because you all may want to decide the sequence that we've come up with doesn't make any sense and you want to go to licensure.
Yeah. Okay, look, I'm previewing what I'm going to say next week, but to me, the order isn't bad. It's the timetable. In other words, I just think all of these may be more complicated than we think, and it's just going to take longer than we thought. I hope I'm wrong. I don't think I am, but I hope I'm wrong.
Okay. Anybody, anything else?
I just want to thank you for for the opportunity, by the way, to speak before you committee. So thank you.
Thank you, and thank you for sharing.
Thank you both.
All
Yeah,
right.
both
thank
of
you very
are
much.
Very helpful, very helpful.
And we're Public Law Center, not Public Counsel, just saying. I love Public
I'm sorry.
Counsel, but don't forget we're here too.
All right. Thank you. Bye.